We have 3 important dates coming up regarding Elizabeth Holmes' sentencing. And I also want to talk to you about whether or not she can object to the sentence recommendation made by the probation department. Hi there, I'm Michelle Hagan. I'm a legal analyst and a former prosecutor. You may recognize me because I provided a lot of legal analysis for the Elizabeth Holmes case. And so let me give you a little background before we get into the sentencing. And I'm going to show you the actual federal sentencing guidelines to lay out the procedure and why we have 3 dates coming up that are really important. So please like, subscribe, and share this video. And thank you very much for those of you who have subscribed, and I appreciate all of your comments. Okay, so the background is her sentencing hearing at this point is scheduled for September 26th. And she was convicted on 4 felonies. 1, a conspiracy to defraud investors, the conspiracy with Balwani to defraud investors, and then 3 wire fraud counts for also defrauding investors. And the amount of money was $144 million. Yes, can I speak today? The amount of money was $144 million. And if you look at my previous video on calculating her sentence, you can kind of get an idea of how much time she's looking at potentially. All right, so let me share with you the sentencing guidelines in particular relating to the pre-sentence report, which is the recommendation from the probation department that they make to the judge what they think is appropriate for Elizabeth Holmes. Okay, so I'm going to show you, we're going to look at a couple sections here from the sentencing guidelines. Okay, so here's the sentencing procedure. So it's a pre-sentence report, and it says the probation officer must conduct a pre-sentence investigation and submit a report to the court before it imposes the sentence. And it also says here, the defendant may not waive the preparation. So even if she doesn't want a pre-sentence report or a recommendation or any input from the probation department, the court is requiring the probation department to submit, and these guidelines require the probation department to put together a pre-sentence report, which is basically they interview Elizabeth Holmes and all the relevant parties, and they make a recommendation. They research if she has any criminal history, if there's any factors in aggravation, and any factors in mitigation, which I will talk to you about in a future video. So let me go ahead with this and show you, because the deadlines, some of these dates are important. Okay, so disclosure. So who gets a copy of this pre-sentence report? So it says the probation officer must give the pre-sentence report to the defendant's attorney, and the attorney for the government. In other words, the prosecutors, 35 days before sentencing. So if I did my math right, and I got to look at my notes here, 35 days before September 26th is approximately August 21st. So we should be getting, or they should be getting, a copy of the pre-sentence report approximately August 21st, at least by then. Okay, so probably mid-August. All right, so then it says under section B, within 14 days after receiving the report. So in other words, that would be September 2nd. Before September 2nd, each party, meaning her attorneys and the prosecutors, can state in writing any objections they have to the recommendation made by the probation department. And these, what kind of objections can they make? Objections to material information. In other words, the probation department got it wrong on what the facts are. Or there's a mistake in the sentencing guideline ranges. Again, maybe the probation department applied the wrong range, wrong category that she's in, or any policy statements committed or contained in or omitted from the report. So whatever the probation officer says regarding policy, maybe it's deterring future crime, maybe it's the impact on the victims, the investor victims, we'll have to see. After receiving the objection, the probation officer may, not shall, may. That means it's up to the probation officer on whether they meet with the parties to discuss their objections. The probation officer may then investigate, not shall, but says may. So it's up to the probation officer to determine whether or not they're going to investigate any of the objections or any further or make any revisions to the report. Then, so the next thing that happens is 7 days before sentencing. So that would be September 19th. And again, that's assuming that the September 26th date holds. So 7 days before that would be September 19th. So at least 7 days before sentencing, so before September 19th, the probation officer must submit to the court and to the parties the pre-sentence report and an addendum containing any unresolved objections, the grounds for those objections, and the probation officer's comments on them. So what does that mean? So the probation officer, 7 days at least before the sentencing hearing, has to submit the final pre-sentencing report and any addendums, and those addendums can relate to any of the objections by, say, her attorneys. Say her attorneys say the range is out of line because of the following reasons, or the probation officer didn't consider the fact that she cooperated, or the prosecutor could say, well, we don't think her cooperation was effective, or whatever facts that they each want to dispute and suggest to the probation officer to consider in their report. All right, and the probation officer will indicate what the grounds for those objections and make the comments. The probation officer could say, you know, I don't think it's relevant that she did or didn't assist, although it is, but you know, whatever it is the probation officer wants to say. Then what happens is if when any factors, so this is a resolution of any disputed factors, when any factor important to the sentencing determination is reasonably in dispute, the parties shall be given an adequate opportunity to present the information to the court. What does that mean? So that means if either of the parties are disputing what is in the probation report, they have the right to ask the judge, to ask the court to have a hearing. So I can tell you, they're more than likely going to have a hearing to determine what the appropriate sentence is and to allow each party to object and to lay out their arguments for why she should get more time, less time, why they agree or disagree with the probation department's pre-sentencing report. All right, now who decides? It says right here, the court shall resolve disputed sentencing factors at the sentencing hearing. So again, it's up to the judge, and I'll just scroll through this if there's anything else. And let's see. Oh yeah, it's up to the judge to make a determination as to what the sentence is. And again, it's in his discretion. And these federal sentencing guidelines, as I pointed out in the previous video, which I encourage you to watch on calculating the possible sentence for Elizabeth Holmes, it's up to the judge. It's his discretion. These guidelines are not mandatory. They're just advisory. Okay, and here's another thing that the judge could do. Before the court may depart from the applicable sentencing guideline range on a ground not identified for departure in either the pre-sentence report or in the party's pre-hearing submission. So in other words, if something else comes up that the judge considers that's not mentioned in the pre-sentence report or in the pre-hearing, the court must give the parties reasonable notice that it is contemplating such a departure. So that means the court has to give notice to the parties that he is, or they are, contemplating a departure from the pre-sentence report and from the guidelines. The notice must specify any ground on which the court is contemplating a departure. I don't think that's going to happen, but I just wanted to bring that to your attention. And then this other part is about the crime victims' right, which I will be doing a video on because I think that's also very important. You know, the victims in this case are the investors, the DeVos family, to the tune of $99 million to, I think it's the PFM Health Sciences Fund in San Francisco. Brian Grossman was the witness to the tune of $138 million. And then the attorney investor, David Mosley, which was approximately $6 million. So those are the 3 potential victims that will more than likely get restitution. So I'll be talking about that in a further video. So I hope this has been helpful. And again, keep in mind as I scroll through here, let me just make it one more pass in case any of you guys want to read this. And hopefully that's slow enough for you. Okay. So keep in mind those 3 dates that are coming up, or 4 dates, okay? The sentencing is September 26th, scheduled as of now, September 26th. The pre-sentence report comes out 35 days prior, so that's approximately August 21st. And then they have the right, both parties, to file their objections to the pre-sentencing report by the recommendation made by the probation department. That is due by September 2nd. And then 7 days prior to the hearing, the probation department will submit its final pre-sentence recommendation. And that would be September 19th. So thank you very much for watching. And again, this is just my opinion, and I'm curious to see what you think about what potential sentencing she could get, or sentences she could get, and what kind of objections do you think she's going to make. And just to give you the heads up, you might come up with some ideas after I get a couple more videos out on factors and aggravation and mitigation. In other words, what the court can consider to increase their sentence or to decrease their sentence. Okay, so please do comment. And please subscribe. And thanks again for subscribing. And let's see, I think that's it. Thank you very much for watching. Bye-bye.